sanctions and international law perspective is to, through the adoption of economic measures by one state, to compel another to change its policies, economic or political. And there's a very useful reference at page 5 of that publication, the Abisab definition, which I'm sure my colleagues will further refer to. And I just wish to quote, extract from that. It says, the ultimate purpose being, as with all forcible execution of enforcement measures, precisely to bend its will in order to bring it back to a conduct compatible with legal prescription. To bend the will of a state, the purpose is to bring it back to conduct compatible with legal prescription. But for that, there's an important qualifier. At page 6, moreover, its determination must be accompanied by a decision, that these measures are taken in application of a decision or recommendation of a competent social organ. So here in international law, we are not talking of unilateral measures by one state or by a collection or a group of states, but a decision for recommendation of a competent social organ. And here, the competent social organ to whom the international community has vested power in terms of the Charter is the Security Council. And here, once again, may I quote from James Crawford, Relationship Between Sanctions and Countermeasures, in a publication edited by Ms. Vera Gowland-Debars, who is with us here. It's very important, and Crawford expresses the view that it may be inferred from the definition of Abisab that a competent social organ is not an individual state acting in its own right, or even a small group of states so acting. Instead, it appears to refer to some organ authorized to act on behalf of a collective interest. I think that's very important, to act on behalf of collective interest, such as, for example, the Security Council. Imposition of national legislation having extraterritorial application is thus contrary to this norm, and as such undermines the collective authority of the Security Council, which is the only competent social organ mandated by the international community to impose coercive measures. I think that captures the essence of the position under international law in respect of recourse to unilateral sanctions. Once again, may I refer to the ICJ judgment in the Nicaragua case in the context of compelling a change of policy. Now here, let us take a situation of unilateral sanction to compel a change of policy. And I think the words of the ICJ is very important at this point. The ICJ referred to the doctrine of rights and duties of states in the context case of military and paramilitary activities in Nicaragua by the United States. And the court upheld the sovereign right of every state, including Nicaragua, to pursue its own political system or its own economic policies, free of intervention by any other state. So that forms an essential ingredient of the doctrine of rights and interests of state. One more word, when we are examining this question of unilateral sanctions, I think it's also useful for us to bear in mind the reaction both within the International Law Commission and in the Sixth Committee to this whole institution of countermeasures in the context of state responsibility, and more recently in the context of responsibility of international organizations. Countermeasures, as we know, is a unilateral measure a state takes which would otherwise be unlawful if not for a prior illegal act by another state. Now, this was shrouded in so much of controversy, given the element of potential for abuse, for political purposes, and number of safeguards, caveats had to be worked in. And in the case of state responsibility, number of safeguards in the form of the test of proportionality. Is the countermeasure in proportion to the original act of illegality? In the case of international organization, the same principle, plus that the rules of the organization must provide that it is not contrary to the rules of the organization to adopt countermeasures. So the international community, even in that respect, where it may be legitimate to take countermeasures, is cautious. And there are a number of caveats that have been worked into these draft articles. So this is something we need to bear in mind, this institution of countermeasures. International community is aware that there can be an abuse of that process. So in our approach to unilateral sanctions, let us keep in mind that the escalation of a situation through recourse to unilateral sanctions can pose a threat to international peace and security, and in that process cause irreparable harm to fundamental principles of international law on which the international order is based today. I will stop there, Madam Chair.
Thank you, Dr. Pereira, and thank you for accepting to be a part of the panel on a short notice. I'll give the floor now to Professor Vera Gollan-Debas. She will take the discussion forward. She'll be speaking on sanctions and state responsibility. Professor Debas is a professor at Geneva School of International Studies, Geneva. You have the floor, ma'am.
Thank you very much, Madam Chair. And I would particularly like to extend my thanks to ALCO, and particularly its Secretary General, Professor Dr. Mohammed, for having extended to me this invitation to be here amongst you. And I'm really delighted to be here. I come from your part of the world, which means that I am particularly committed to ALCO's goals, which is to see to it that the African and Asian states feed into the development of international law, so that ultimately it is not just left to a cross-Atlantic dialogue. I think that goal is extremely important, and ALCO has obviously done that in the past in huge areas of international law. So thank you again, Professor Mohammed. Now, my topic is on sanctions and state responsibility. I would like to focus on individual state accountability for the imposition of economic measures, and from the perspective, of course, of, as I've said, of state responsibility, but that will also include human rights law. But I examine this from a particular perspective. In other words, what interests me is the relationship between unilateral measures and collective measures, because we've seen increasingly the embroilment or the intertwining of these two areas in recent practice, and I think it's important to see how they relate. And I would like to pick up on Dr. Pereira's intervention to, first of all, stress the importance of the ILC articles on responsibility, which has, in fact, reserved the term sanctions for institutionalized measures adopted through international organizations, i.e. centralized collective measures, and in particular those of the Security Council under Chapter 7. And the ILC was obviously reflecting general international law in this matter. The ILC therefore distinguished between sanctions and unilateral measures, which it has termed countermeasures, as decentralized reactions in response to illegal conduct by other states, as pointed out in this introduction. Now, it's evident that the progressive institutionalization of international society with the development of international organizations has had a very important impact on the enforcement of international law. And this has gone hand in hand, first with the progressive limitation of the use of force, as we know in international relations, but also with attempts to constrain countermeasures. The term, by the way, was first used in the 1979 Air Services arbitration between the US and France, and was meant to be a euphemism to distinguish it from forcible reprisals. In other words, that was the detachment of countermeasures from the use of force. We all know their negative impact on trade, investment, and so on, right to development. This has been underlined in numerous General Assembly resolutions. And in the ILC, there was a controversy over whether to include countermeasures at all in the articles on state responsibility. They were recognized as liable to abuse and in view of the factual inequalities of states. In other words, they were obviously measures which were open to some states and not to all. So the ILC ended up by adopting the regime of countermeasures, but accompanying this with a very strict framework in order to avoid abuse. Now, the ILC, by the way, was not the only efforts to constrain countermeasures. We've had regulation or prior conditioning or subsequent control by international institutions, for example, trade measures under the law of the WTO or the European Union. Now, I will focus on the ILC articles. There is now, obviously, we have a framework for unilateral measures, but at the same time, and this is what I mean by the interrelationship between unilateral and collective, we've had an ongoing debate on how to also constrain collective measures. In other words, the Security Council has been challenged also in the field of Chapter 7, in particular its anti-terrorism resolutions. Now, the idea was that the states could not escape the conditions on unilateral measures by hiding behind the collective veil. So in a way, the ILC efforts impacted on the collective measures. And there was once a huge discussion in the ILC on whether to integrate UN mechanisms into the ILC drafts, but finally the ILC decided to exclude collective measures from the scope of the state responsibility. However, my point is that they continue to be extremely relevant. So what I'm focusing on, as I've said before, is collective or unilateral measures adopted in parallel with collective measures. And I would like to give as a very good example the series of economic measures adopted by the United States against Iran, because I think it's important there. It provides us with a framework for an analysis. Now, the first question to be asked about these sanctions, should they be seen as implementation or enforcement of Security Council sanctions? If they are seen as implementation or enforcement, they would benefit from certain circumstances precluding wrongfulness. In other words, they would be regulated by Article 25 of the Charter, which imposes an obligation on member states to carry them out, as well as Article 103 of the UN Charter, which means that the obligations under the Charter would prevail over any other international agreement. If they're not to be seen as implementation or enforcement, in that case, the only justification would be lawful countermeasures. And if so, what are the conditions that apply to them? So, are they implementation of Security Council measures? I have no time to go into great detail, but if we look at their legal basis, the web of legislative and executive measures imposed against Iran were first adopted in the 1980s. In other words, they preceded the adoption of collective measures. And as you know, the US has a long history of using economic sanctions as a tool of foreign policy. This goes right back, in fact, to the 19th century. So it's obvious that these measures in the 1980s and beyond did not invoke the UN Participation Act, which the United States adopted in order to carry out measures by the Security Council. Instead, the measures generally have as their basis a number of domestic legislative acts, including the 1977 International Emergency Economic Powers Act, the IEEPA, which was first used in 1979, following on the hostage case, as a legal basis to block Iranian assets and so on. Now, the importance of that, and there, in fact, the first use of the UN Participation Act was only in 2001, following on 9/11, which blocked property and prohibited transactions with persons determined to be supporting international terrorism, which included the freezing of the assets of certain Iranian entities. But